Hello, everybody. This is week 4 here at Park University at CJ105. My name again is Bill Bauer. I'm your instructor for this particular course. Or you may have another instructor if you're not in my particular class, but I'm the developer, so I do these lectures. This week, this is week 4, your assignment will be to work with discussion board. That's the only assignment you have for this week. Although if you have not finished your essay for last week on either parties to a crime or one of the inchoate crimes, just one of the inchoate crimes, then you need to get that completed as well. Again, remember, discussion board must be in your own words. You must do some research beyond the textbook. Use the web bibliography area that we have provided, in which I've given you some extra websites that you can look at to research some of these topics. Also use the Park University McAfee Online Library. It has lots of good information that's available to you and fairly easy to use. So this week we're just doing a discussion board. Remember, you have to answer 2 questions yourself, preferably 2 questions that have not been answered by other students already, as well as 3 quality replies to fellow students or myself. Quality replies, again, means that you are adding information or understanding about the topic through examples, additional research information, case studies, hypotheticals, and so on. All right? You have to go beyond simply giving a compliment or simple agreement. This is a discussion, just as if you were in a classroom, an actual classroom setting, and we're discussing the topic, and we're adding information and understanding, clarifying things. So that's what the discussion board is. Remember that your initial responses answering the questions must be submitted no later than 11:59 p.m. Central Time on Thursday night. That's if you want full points. Okay? Now this week we have several different topics. We're talking about defenses this week. Defenses to charges of wrongdoing. Now there's 3 primary categories of defenses. The first is alibi. Very simple. Alibi is, I couldn't have committed the crime because I was someplace else. Okay? That's fairly straightforward. We're not going to get into much detail about alibis. Then we have justification defenses. That's a category of defenses, justification, which essentially means that, yes, I'm responsible for the act, but I was justified in doing it. Okay? Then we have excuse defenses, which says, yes, I committed the act, but I cannot be held responsible for it for some reason. There's an excuse for it. Now, one thing about defenses we have to understand is most of these, whether they're justification or excuses, are affirmative defenses. An affirmative defense means that the defense attorney or defendant must prove or demonstrate that the defense exists, that it's there. They have to prove their defense. Once they've done that, then the prosecutor, the burden of proof shifts back to the prosecutor again to prove that that defense does not exist, that it cannot be applied. There are several different ways in which we can look at defenses. One is if we have a perfect defense. A perfect defense, you get acquitted, like an alibi. You have a rock-solid alibi. You could not have committed the robbery because you were 5 states away at the time. You are acquitted. That's a perfect defense, is if you get acquitted. Then we have imperfect defenses, which can reduce the charge. We have mitigating circumstances. If you have a defense that mitigates what has occurred, then maybe you get your sentence reduced, your punishment is reduced. One thing that can be used in punishment as well as convicting somebody, of course, is motive. Many people will get confused with motive, and we're just going to mention this briefly because it is important. It can be brought up as a defense. Hey, you had no motive to commit this crime. However, the prosecution does not have to prove a motive. Motive is the reason why a person committed a crime. We're not required as prosecution, as law enforcement, to prove a motive. Okay? We have to prove intent to commit a criminal act. We have to prove the voluntary act itself, voluntary criminal act, concurrence between the two, causation, and resulting injury, whether it be physical or financial. But we don't have to prove a motive. But it can become influential in the case. Now, we're first going to talk about justification defenses. Okay? Now, if somebody asks you what is a justification defense for this particular crime, let's say robbery, what types of justification defenses could they use? Okay, we can't say, well, they can use justification defense because that's a category, an umbrella, under which there are several. Some of the justification defenses include self-defense, defense of others, defense of home and property, choice of evils defense, also known as the necessity defense, and defense of consent. Those are all justification defenses. So let's talk first about self-defense. As a result of several recent cases, particularly down in Florida, many people get confused with stand your ground, and they refer to that as a defense. Stand your ground is actually self-defense. But what it is redefining self-defense in a public area. Okay, it's still self-defense. Originally, self-defense could only be used when it was reasonable to do so. If it was reasonable for somebody to, in the public sector, I mean, you're out in the public someplace, you're in a park, you're on the street, you're on a sidewalk. If it was reasonable for you to retreat from an attacker before being attacked, you had to do that. Okay, and in many states, you still must do that. Stand your ground reflects the castle doctrine. The castle doctrine originally said that once you are in your home, you're in your residence, you have no requirement to retreat if attacked. Okay, it doesn't make any sense if you're in your home and somebody breaks down the door and attacks you. Why do you have to retreat from your own home? Okay, that's called the castle doctrine. And what many states have done is extended that through what we refer to today as stand your ground statutes. And so now if you're in public and you're attacked, you reasonably feel that you're being attacked, you can then use self-defense. Self-defense, however, has a requirement. The attack must be imminent. In other words, somebody can't do, if somebody just says, I'm going to beat you up, but they don't do anything, they don't take any action to do so, you're not under any threat. You cannot use self-defense. So it has to be imminent. The person that must have raised their arms, grabbed a weapon, done something besides make a statement. It has to be unprovoked. In other words, you cannot provoke the attack. So if you go up to a person and start calling them a bunch of names and things and provoke them into attacking you, you cannot use self-defense. Right? Self-defense is simply you are in an unprovoked attack. Somebody is attacking you. It's unprovoked. It's imminent. Right now, it's going to happen. And you have to have a reasonable belief that you're going to be injured. Now, the amount of force that can be used to repel this attack must be reasonable. In other words, if somebody takes a swing at you with their hand, you cannot use deadly force. Then you would be charged with voluntary manslaughter or involuntary manslaughter, maybe even murder, depending on what they can find in as far as other circumstances, other facts. Okay, so for defense of yourself, you can only use that amount of force necessary to repel the attack, no more than that. Any more than that, you end up getting charged yourself. All right? So when we talk about stand your ground type of, hang on a sec. Okay, I just want to make sure my camera was still running. If you are attacked by someone, you can only use the amount of force necessary to repel the attack. Maybe it's just pushing the person away. Maybe it's kicking them or hitting them. Maybe it's giving them, if you know judo, you give a judo throw. Maybe it's you're picking up a stick because they have one. But you cannot use deadly force. A lot of people they look at stand your ground doctrine. Oh, it means I get to use deadly force. No, no, no. Deadly force is only used when you are in absolute fear of imminent death or great bodily harm. Period. Okay? And remember, stand your ground is simply an extension of the castle doctrine, eliminating the retreat requirement of the old days. It's still self-defense. Okay? Self-defense. Defense of others. Every state allows for some defense of others. Some only allow for defense of others who are close to you, your children, your parents, family members, close friends. Other states allow for the defense of others, and that means any other innocent party. That becomes difficult if you're the person that's attempting to use this defense. If you see two people, see one person about to injure another person and you step in to give defense, you may be in the wrong, because if the other person that you're defending provoked the attack, you have now become part of the offender side of the case. But defense of others, in some states, again, you have to have a special relationship with that person. In other states, defense of any other innocent party is sufficient. But everything that I talked about as far as use of force in self-defense applies to defense of others. Defense of home and property. Now that gets to be a little stickier. Generally speaking, we're allowed to use, a person can use defense of property, defense of home, all the way up to use of deadly force, but cannot deadly force. We do not use deadly force to, say, stop a person from stealing our car from our driveway, right? And the reason the states don't allow that is because property can be replaced, and most property is insured, and you'll get a replacement. So if somebody's stealing your property, damaging your property, deadly force is not going to be allowed. But we can use reasonable force to stop a theft or damage to property. Now, what some of you are probably aware of, like in Colorado and Texas, they have extended or made more liberal the use of deadly force in protecting home. What you have to understand is deadly force is still the last option. You're still required, even in those states, to use only that force necessary to stop an attack upon yourself or your family members, or to stop the theft of property. Deadly force is allowed in more cases in those states because simply breaking into a home is considered a potential threat to life or great bodily harm. So they've liberalized their law enough so we don't second guess the use of deadly force if an offender has broken into the home. Now, it can still become a problem, and has become a problem for several people. There was a recent case in Texas, in 2012, there was a case in Texas where a person attempted to use their Texas statute about protecting property. The problem was that the property wasn't in the home, it was outside the home, it was a car or something, and the person used excessive force. There was no reason to kill the offender. And they were charged for excessive use of force. In the civilian world, that usually is involuntary manslaughter. So we have to be very careful. It's not a blanket coverage. Oh yeah, if somebody breaks in your house, I automatically get to shoot somebody. It's not the case. Okay. However, in those states that have liberalized the defense, they're not defending home, they're not defending property per se, they're defending themselves. And what those states have recognized is prima facie evidence that if somebody breaks into your home, you are in danger. So therefore they get to use, have more access to the use of deadly force in those circumstances. Another justification defense is choice of evils. We also refer to that as necessity defense. Choice of evils, you can almost look at self-defense as choice of evils. However, because it's a separate defense, we don't categorize it as such. Choice of evils is when somebody commits an act that would normally be a crime to try to reduce or eliminate some greater harm. All right. Now the textbook says reduce some other more harmful crime, but it's not so much as much a crime as it is something more harmful. And it gives the model penal code gives some examples. For example, somebody is severely injured and bleeding severely. You put them in a car and you speed. Okay. Choice of evil. Speeding is a lesser evil than letting a person bleed to death. Somebody gets lost up in the woods during the winter, and they come across a cabin. Breaking into the cabin to stay warm is a lesser evil than freezing to death. One that's very popular when we talk about examples, there's a huge forest fire going, and I've actually seen this happen, okay? Huge forest fire is going, it's out of control, it's coming up to a town. If the forest fire gets to the town, it's going to wipe the town out, right? Because this fire is just roaring. So what a person does is goes over and goes to one of the first houses, or maybe the first couple of houses in the town that's facing the oncoming fire, and sets them on fire, creating a fire break. A fire break is creating a zone of dead material, burned out material. They obviously can't burn again because it's already been burned out. So they burn these houses in order to create this fire break so the fire has no more fuel and can't enter the rest of the village or the town. Normally that would be arson, but because burning down two houses is better than allowing the entire town to burn down, choice of evils applies. Now, excuse me, when a court looks at choice of evils, there's a test, okay? And this is something you should really understand, is there's always a test involved in criminal law. We test to see if this is true, or if that's true, or if their choice of evils is a good defense, there's a test. You probably remember earlier we talked about equal protection clause. There were 3 different tests to determine if the law was invalid or not. Choice of evils, there's 3 parts. First, identify the evils. Okay, you got to identify what is the evil that's occurring. Is it a fire? Is somebody injured and bleeding to death? Is somebody going to freeze to death? What is the evil that we're concerned with? Then we have to rank those evils, and then choose the lesser evil to avoid imminent harm. Now it has to be imminent. We can't say, well, you know, forest fire is 10 miles away. Or 20 miles away. We can't say, well, from burning down these 2 houses to create a fire break for a fire that's 20 miles away, because it's not imminent. It's not going to happen now. So it has to be imminent harm from the greater evil. So there's 3 parts to the test the courts will look at. They'll look at the evil itself. They'll rank all the evils involved, including the one the person took. What other options, alternatives could they have taken? And then the court will decide what is the lesser evil that could have been used or was used to avoid the imminent greater evil. Okay? So remember the test, list all the evils, rank all the evils. Did the person use a lesser evil than the one that was going to occur? So what is the evil? What are some of the alternatives that were available? Was the alternative used less than the evil that was going to occur? The last justification defense that we're going to talk about is consent. Consent is a justification defense. In other words, I had consent. Yes, I did what you said I did, but I had consent to do so. There are several things that have to occur, parts to the test to determine if consent is valid. First off, there was no serious injury resulting from the consent. Now, nobody went to the hospital, nobody was killed. The injury occurs during sporting events. Okay, if you're in a sporting event, like football, hockey, baseball, whatever, we certainly can't charge all the players for assault and battery, or aggravated assault and aggravated battery, and so on. It's part of the sport. The consent benefits the person who consents. Okay, patient consents to surgery. So if the person giving the consent is benefiting from it, that'll make it okay to do. Consent is sexual conduct. If a person is of age of consent, now that states vary, 14, 15, 16, 17 usually, someplace in that range. If they've reached the age of consent, they can give consent to sexual activity. You can give consent for somebody to take your property. If you tell your next door neighbor, hey, go ahead and take my car, you can't later on go, if you argue that they stole your car, they have the defense of consent. Now, some things about consent that we have to understand and remember is the consent must be voluntary, right? It can't be coerced. It cannot be no threats, no lies. The person has to know what's going to happen, why they're giving consent. The person must also have the ability to give consent. As I mentioned earlier, if a minor has not reached the age of consent, they cannot give consent. If a person is somehow incapacitated, they cannot give consent. If they have mental defects that prohibit them from making legal decisions, they cannot give consent. So it has to be voluntary, has to be knowing, and they have to have the authority. All right? A person cannot give consent to another person to kill them. You just can't do that. You cannot consent to murder. But many other crimes, there can be an argument that consent was given. Okay? So those are the primary justification defenses we're talking about. We can have consent, choice of evils, defense of others, defense of home and property, self-defense. Now we have excuses. Okay? Now I want to make sure I list these things. We have alibis. We have justification. And excuse. Categories of defenses. All right? Excuses. It differs in that excuse defense, remember justification was yes, I did it, but I had a good reason for doing it. I had justification. Excuse defense is yes, I did it, but I cannot be held accountable for some reason. Some of these might be insanity, diminished capacity, age, duress, intoxication, entrapment, or some type of syndrome. Okay? Essentially what an excuse defense is going to do is impact either the voluntary act or it's going to impact the mens rea requirement, the criminal intent requirement. For example, insanity is an excuse defense. Although it's illustrated or shown on television programs as happening a lot, reality is that insanity defenses are used in trials less than 2% of the time, actually about 1.5% of the time. So out of every 100 cases go to trial, maybe one case will attempt the insanity defense. And only a small portion of those are even successful because it's very difficult. It is an affirmative defense, which means the defense has to prove it exists. And they have to use whatever test the state is currently using. Now, most states have gone to the Model Penal Code substantial capacity test. Some states are still using the McNaughton test, which came from England in the late 1800s. And so we call it the right-wrong test. McNaughton is a right-wrong test. Not as simple as it sounds, really. What it essentially means is that at the time the person committed the criminal act, whether it be some kind of property crime or some kind of crime against persons, they were under a mental illness. They have to be suffering a mental illness such that their ability to determine right from wrong, in other words, form the criminal intent, was impacted. They could not make that determination. Okay, so that's a very simple test, but it places the burden of proof on the defendant. They have to show an existing mental illness. Okay, and mental illness is not as easy as people think it is to fake, because they would have to fake it all the time. They would have to fake it when they go to lunch. They would have to fake it amongst their friends. They would have to fake it amongst strangers. They would have to be faking it all the time, which is virtually impossible. Then they would have to be able to fake it to trained professionals who can see a fake or have been trained to identify fake mental illnesses. Another factor is that the mental illness involved has to be one of those identified in law. Okay, there are many mental illnesses that psychiatrists and psychologists will talk about, but only a few are legal mental illnesses that can be used in a defense. So it's very difficult. Very, very few cases attempt to use it. Even fewer are even successful. It just doesn't happen that often. And when it does, the person who is using the insanity plea is generally insane. They cannot form criminal intent. I have a quick example for you. We used to have a gentleman in my district as a police officer. Big man, probably 6'4", 6'5", pushing in 250, 260, all muscle, huge man. But he had a mental illness, inherited. His mom had the same mental illness. We had to deal with her at a different time. But this gentleman, when he was off his medication, would imagine things. And normally what we would have to deal with as law enforcement officers was when he would imagine a family of ducks that needed to cross one of the highways. And several times we found him crossing his imaginary ducks across a state highway. He would stop traffic, cross these ducks. He did not realize that he was doing anything wrong. He believed that there were ducks there, and he believed he had a responsibility to ensure the safety of those ducks and make sure cars and people did not disturb them. So he had a mental illness that kept him from understanding that what he was doing was wrong. Because to him, it wasn't wrong. Okay? So that's true mental illness. We got to the point with him, we didn't even bother, whenever he would do such a thing, we'd wait until he got his ducks across. We'd help him get his ducks across, because then he was very peaceful. He would get in the back seat of a police car very peacefully. We would take him to the hospital to get his medication. That was just the best way to handle that individual. Another type of mental illness defense or insanity defense that wasn't as popular but is out there is one called the irresistible impulse test. A person is suffering from a mental illness that makes it impossible for the person to resist the impulse to do something even though they know it's wrong. So this is not a right-wrong test. This is where they just can't avoid it. There are some people who have an irresistible impulse to light a fire. Probably the most famous one is the person who is a kleptomaniac. They lack the ability to resist the impulse to steal. Okay? So they know it's wrong, they just can't stop themselves. They can't help themselves because their brain wants them to do so. So these two different tests, McNaughton and irresistible impulse, are sitting out there. Irresistible impulse wasn't used very often because it's so limited on the types of illnesses, didn't reflect on right and wrong. Later on, we come up with the substantial capacity test. You'll find it in the Model Penal Code. And essentially what the Model Penal Code did was combine the McNaughton and the irresistible impulse test together to create the person has a mental illness that substantially incapacitates their ability to do the right thing. Okay? That's a very short, clear idea of what the Model Penal Code uses for the substantial capacity test. In many states, in fact most states today, are using substantial capacity. One state and the federal government are still using the Durham test. The Durham test looks at mental, the act is a product of mental illness. The reason why only one state's using it, last I heard there was only one in the federal government, is because it's such a hard defense or test to even explain, to define, because we have, what you're saying is the mental illness, or we're reversing everything. We're saying that the act, whatever the offender did, was a product of a mental illness. That's more difficult. It's kind of going backwards, and it's more difficult to work with than the McNaughton or substantial capacity test. So that gives us our insanity test. Again, the burden of proof belongs to the defendant. They have to prove that they had a mental illness, that it affected their ability to do right from wrong, or know right from wrong, or avoid an impulse. Once they've proven their case or shown their case, it's up to the prosecutor then to prove that no, it doesn't really exist. And there used to be a time when both sides would bring their own psychiatrists and psychologists. Many courts today will get their own, so we don't have one being paid for by the defendant, one being paid for by the state. The court will get one that will be more neutral, and that way we only have one person testifying in court. Diminished capacity is another defense, excuse defense, essentially saying that the person has a mental deficiency that inhibits their ability to form the mens rea. Most states are not using diminished capacity any longer. Some people will use it, some states will use it as far as looking at people who have dementia, who may have Alzheimer's, as having diminished capacity. For those of you who run across elderly people or even semi-young people who have developed dementia or Alzheimer's, you can see they have no clue what's going on around them. They're living in a different planet. So that's kind of a diminished capacity, but most states aren't using that test. Age as an excuse defense. Age, under common law, anyone under the age of 7 and younger, could not be held criminally responsible, period, for any crime. Between 7 and 14 was kind of a gray area. It could be, if it could be demonstrated that they were mature enough to understand what they were doing and the social consequences and personal consequences involved. From 14 and above, they were charged with a crime. Okay, but remember, common law, we're talking somewhere between 1000 AD through 1800 AD. We had very little information about brain development and those kind of things. Today, we view it a little differently. Age can still be a defense. And what we see at ages of defense is the lack of brain development today. There was a study done a couple of years ago. In 2012, the U.S. Supreme Court came out with a decision concerning the death penalty and life without parole on juveniles, and said they cannot be given those punishments because they lack the brain development to make rational decisions, to avoid impulses, because the frontal part of the brain controls all that, and that part is still being developed up to the age of about 21. So age can still be a defense. So when we're talking about age as a defense, please don't talk about what the statute says. Well, if they reach this certain age, they can be tried as an adult. That's by statute. But even if they're tried as an adult, they can still use age as a defense in an adult court. So age can be a defense. Other excuse defenses is duress. Right? Duress is individuals who commit crimes because they're threatened with harm if they don't. Now, maybe harm against themselves or loved ones. There's no actus reus because they're being forced to do it. There's no mens rea because they're not creating a criminal intent. They're reacting to the coercion or duress. Minor crimes will qualify for this defense. Generally, murder will not. I mean, if you are personally threatened, your life is threatened, you're not going to be able to use duress. In most states, probably 49 states, are not going to allow you to use duress to kill somebody else, to excuse your murdering someone else. Some of the things that have to apply is, first off, there has to be threat of bodily harm to you or a loved one. That threat must be imminent. Okay? If somebody across the country threatens to kill you, threatens to injure you severely if you don't commit a crime, there's no imminency to it. They can't do it right now. It has to be imminent, like right now. And then, of course, the court's going to measure what act you did as compared to what the threat was against you. But usually it's going to have to be a very serious threat. Almost all property crimes can be defended using duress or coercion. Okay. Now, in your outline, we also have intoxication as a defense. There's voluntary intoxication and involuntary intoxication. In your in the notes in the weekly area, you'll notice in the outline it says there is no excuse for voluntary intoxication. It's no defense. Actually, it can be a partial defense, an imperfect defense, if you will. Because we have two types of crimes: specific intent crimes, general intent crimes. Specific intent crimes are crimes that have a specific result that has to be proven. All theft type crimes, larceny, robbery, burglary, fraud, embezzlement, all of those are specific intent crimes because we have to prove as prosecutors that there was intent to permanently deprive the person of that property, and we have to prove what property it was. We can't just say, well, they intended to steal some property, but we don't know what it was. You have to know what it was. You have to be able to prove it. Specific intent. First-degree murder is a specific intent crime because it's premeditation, or it's under a felony murder case where the killing occurred during the commission of one of the 5 listed felonies. Okay? So it's very specific. We have to prove certain things. Now, in specific crime cases, which also include, I might as well finish this, assault, attempt, conspiracy, solicitation, possession, all of those are specific intent crimes. But voluntary intoxication in some states will allow that, allow for a partial or imperfect defense in that it will mitigate a specific intent crime down to or over to a general intent crime. General intent crimes include second-degree murder, manslaughter, battery, arson, kidnapping, rape, these are general intent crimes. So, breaking and entering, simple breaking and entering with no intent to steal is a general intent crime. So if somebody gets really drunk, and we're talking for intoxication to be a defense, the person has to be so intoxicated that their ability to decide right from wrong has been impacted. That's really, really drunk, folks. I mean, we're talking way beyond simple drinking and driving. They're just so drunk they can't tell the difference from right from wrong. And in those cases, check. Yep, we're still going. All right. In those cases, it can be mitigated. For example, burglary could be mitigated to breaking and entering because it cannot form the specific intent to steal. First-degree murder can be mitigated to second-degree murder because they cannot premeditate something if they're too intoxicated to make rational thought. So voluntary intoxication is generally viewed as inexcusable, but can, in some states, mitigate specific intent crime to a general intent crime. Now, involuntary intoxication, this is when a person becomes intoxicated, either not knowing they're becoming intoxicated, or they're forced to become intoxicated. Maybe somebody has poured some alcohol in the punch at the high school prom, all right, and somebody drinks lots of glasses of this punch not knowing that there's alcohol involved, and they become intoxicated. That's involuntary intoxication. Date rape drugs. They're dropped into a drink. No person who drinks it doesn't know that there's a drug been put into this thing. So involuntary intoxication can be a defense, and it can be a perfect defense. But again, the person has to be so intoxicated, either by drugs or alcohol, they have no idea what they're doing. All right? So that can be a defense in any case. Entrapment. Entrapment can be a defense. There's two different tests for entrapment. One's the objective test, the other is a subjective test. The subjective test, majority rule, meaning that's a legal term, meaning that most states are using subjective tests. Did the criminal intent originate with the government? Was the defendant predisposed to commit the crime? In other words, if I walk as an undercover officer, I go up to a criminal and, hey man, I want to hit. I need to hit real bad. And the guy sells it to me. Not entrapment. He was predisposed to do the crime anyway. Right? The government didn't put the idea of committing crime in their head. Now, it can get very touchy. If a person, if in the scenario I just gave you, if I say I need a hit, and he says, no, I'm not selling, I don't do that kind of thing, I'm not selling to you. And I keep pressuring, I keep raising the amount of money I'm going to give. Hey, man, look, I'll give you $500 for just one line of cocaine. And I keep pressuring. Now the test shifts from where the government is placing the idea of committing this crime into the mind of the individual. They were not predisposed to commit the crime because they didn't do it. So there's a fine line at some point where law enforcement has pressured somebody into committing a crime versus they were predisposed to do it anyway. The objective test, fewer states, a minority of states use this. Did the criminal intent originate with the government? Would an ordinary law-abiding people be tempted to commit the crime? Okay, that's more difficult. How do you define what a law-abiding person or citizen is? Every law-abiding citizen could decide to commit a crime at any given time, depending on circumstances at the time. It can be dismissed. The charge can be dismissed even if the defendant was predisposed. That's why the minority of states use that test, because predisposition is a clear indicator. If they're predisposed to commit the crime anyway, then there shouldn't be any entrapment. So a minority of states uses the objective test, where did the state put this in the person's mind, and instead of were they predisposed, it's would a law-abiding person commit this act? Okay? Well, you know, if I had to go up and ask a person, hey man, I need a hit, a law-abiding person would not do that. So it makes it difficult for that test. So that takes us through most of the different excuse defenses. There's also syndrome elements for different syndromes, different illnesses, take away the ability of the person to create the mens rea requirement. So we have reached the end of this week's topics. We've talked about an alibi, very simple. I couldn't have done it because I was somewhere else. I was with someone else. I was doing something else. Justification defenses, self-defense, defense of others, defense of property and home, choice of evils defense. Those are all justifiable. Excuse defenses, insanity, diminished capacity, coercion, duress, essentially the same thing, interchangeable words. Entrapment, different types of syndromes, age, those are excuses, excuse defenses. What you need to understand, and what we all need to understand when we're dealing with criminal law, is there are defenses. Just because somebody commits an act, and we can show that yes, they committed a voluntary act, yes, they did, and they thought about it, they may not be able to form the mens rea. They may not be able to. Excuse defense could be involuntary acts. Yes, I committed the act, but I was having an epileptic attack at the time. Okay, that's an excuse defense. So there are excuses and justifications for doing certain things. Okay, we use justification defense even for in states that still have the death penalty. Because technically, when the person, the doctor, whoever, inserts the needle to give the drugs that will execute an individual, they've committed murder, right? But it's justifiable. It's a defense. Yes, I did it, but I was justified in doing it because the law says I can. Okay? Same thing with self-defense. So think about these, categorize them yourself, put them together, look at the outlines in the week, and as well as the written lecture to get a little more clarification. But understand what defenses fall under justification, what defenses fall under excuse, because it will be important later in your final exam. Hint, hint, hint. All right, if you have any questions, problems, concerns during the rest of this week, be sure to contact your instructor, whether it be me or another instructor. My email and cell phone number is in the syllabus as well as in the office area of the course. Okay, so everyone have a great week. Hope you enjoy yourself, and we'll see you next week.